If you think creating a trust is enough to protect your assets, think again. Without this crucial step we're covering today, not only will your assets not be protected at all, you could still end up in probate court. In today's video, I'm going to show you how to use living trusts and land trusts to, number one, secure your real estate assets, but secondly, make sure there is a smooth transition to pass these assets on to your beneficiaries without probate court. Stay around till the end, because if you miss the final step, your trust could be completely empty and you could leave yourself open to attorney attacks. Okay, did you know that creating a trust by itself does nothing to actually protect your assets? You must take the crucial step of making sure you transfer ownership of the asset from yourself, your personal name, into the actual trust. Without this step, your assets aren't actually part of the trust at all. I've seen this happen over and over again, where someone sets up a trust for, say, a piece of property, but they never actually complete the process by transferring the title over from their personal name into the trust ownership. When it's time to pass on the trust documents, the next person inherits an empty trust with no assets in it. That's why funding your trust is absolutely essential. Without transferring your assets into it, you've set up a trust and you've missed out on all the benefits a trust can truly provide. Before we jump into the actual process of transferring core assets into a trust, let's step back for a minute and let's talk about these basic concepts so we understand why this is so important. When you fund assets into a trust, you're not just moving things around. You're actually transferring ownership of the asset into the trust and technically over to the trustee. This is a crucial distinction because trustees actually hold title to those trust assets, but they manage them and hold them for the benefit of the beneficiaries. So what does this mean in practical terms? Essentially, you are transferring either legal title or equitable title to the name of the trustee. This action ensures that both the name of the trust and the name of the trustee appear on the title. For example, if I were the trustee of the Yellow Jacket Trust, it would actually appear on the title as this: Jeff Hampton, trustee of the Yellow Jacket Trust. This designation makes it crystal clear that I hold this asset with a fiduciary duty. I must hold and manage these assets for the benefit of the beneficiaries listed in that trust. Understanding this process is key to properly funding your trust. Without transferring title correctly here, the assets won't actually be part of the trust. And that means you're going to miss out on all the estate planning benefits of a trust, and it provides you no asset protection whatsoever. So as we move forward here, just remember, properly transferring title to the trustee for the trust benefit is a foundational principle that if you overlook this, you throw everything you have out the window when it comes to trusts. So let's say you want to set up your trust, but you're trying to figure out, for my living trust, what should I name it? Well, here's the good news. You have total and complete freedom to decide what you want to name your living trust. Unlike LLCs, if you want to set up an LLC in any state, you've got to go search the Secretary of State to find out the name registry and whether or not your particular name you're interested in has already been taken. The great news, though, about trusts is there is no name registry when it comes to a trust, so you can name it whatever you want. For example, I might set up a trust to hold titled assets in the name of the trustee. And it would go something like this: Jeff Hampton, trustee of the Yellow Jacket Trust. Here's the cool part. You have flexibility on how you list this on your asset titles. If you prefer not to have the trustee's name listed at the beginning, you can make it the Yellow Jacket Trust, trustee Jeff Hampton. This flexibility allows you to personalize your trust and to customize how it's presented on official documents. It seems like a small detail, but it can make a big difference in how your trust is perceived and how it operates. We've just covered two different ways that you can title your trust that are acceptable, either one of them. One could be to list the trustee's name first, then the name of the trust, or you can reverse that and put the trust name first with the name of the trustee after it. Now you might be thinking, Jeff, I don't get this. Why do we have to list the name of the trustee at all? Why can't we just list the name of the trust, the Yellow Jacket Trust, and call it a day? Well, here is where things can get tricky. So it does matter. If you fail to list the name of the trustee, you can cause some big problems with your trust. If you only put the trust name on the title without mentioning the trustee at all, you could unintentionally cloud the title for your property. That means whenever you want to sell or transfer the assets in the future, you could have an unexpected delay, or the cloud on the title could derail the entire sale. Unless you're working closely with an attorney like myself on speed dial, and let's face it, very few people are on speed dial, you could be running into some very serious problems in the selling of a property with this situation. Title companies and legal entities typically require the name of the trustee to be listed in order for everything to be above board on a title transfer. They have to verify who has the legal authority to act on behalf of the trust. So, including the name of the trustee is not just a formality. It is an essential foundational element you must meet in order to prevent future problems. Okay, now let's move on to the exciting part, transferring real estate into a trust. So how exactly would you transfer real estate into a trust? Now, the process we're going to discuss would be pretty much the same whether you're talking about a living trust transfer or a land trust. Now, imagine you have a property and you want to transfer it into a trust, ultimately to help you set up asset protection, but to also protect you for estate planning purposes. Let's use Stacy as our example client. Stacy owns a piece of real estate and she wants to transfer it into a trust. What does she need to do? She needs to deed the property from her name into the name of the trust and the name of the trustee. And this is done through the use of a warranty deed. And be careful here because I hear people on Facebook forums and all over the place talking about using a quitclaim deed. I never advise people to use a quitclaim deed. By doing so, you could end up jeopardizing your title insurance in the future. So Stacy would transfer title to the property to, say, Jeff Hampton, trustee, Yellow Jacket Trust, and she would make sure and put the date of the trust on the title. This action moves the title of the property out of her personal name and into the ownership of the trust. Now, wait a minute. In many cases, with investment properties, particularly like rental properties, Stacy may not want her name in public record associated with the title ownership of any of these assets. In this situation, she could use a nominee trustee or maybe a Wyoming LLC as the trustee. Now, when I say not a nominee trustee, what do I mean by that? You can use a third-party trustee. That could be, say, an attorney. It could be some other third party that you really trust that at the initial transfer would list the name of that particular person as the trustee. Then they would immediately resign and then you would become that successor trustee. But on public record, on the title of this property, the only person who's ever listed, the only name that's ever listed on a trust and public record is the name of the trustee. So if you use a nominee trustee, it will never be associated with you. Alternatively, using a Wyoming LLC, Wyoming has the benefit of total anonymity, privacy that exists under Wyoming law. So if you use a Wyoming LLC as the name of the trustee, no one will ever know your name is associated with it. So both of these options provide the privacy if you're worried about having a rental property associated with your name in any way whatsoever. On the other hand, if Stacy is just transferring her property over into the trust and she personally lives in that property and she's not renting it out, then she can use the process we just discussed a few minutes ago where she can list her name as the actual trustee on the trust. So in this example, she would actually do the transfer to Stacy, trustee of the Yellow Jacket Trust. Now remember, I know we've been talking about trusts in general, but if you're using a land trust and a living trust, two different things. Living trusts are used very exclusively for estate planning purposes to help you avoid probate court. Land trusts are used almost exclusively to be able to help you do title transfers for rental properties and assets that you want to keep private. Any of those situations, you want to keep the names of those trusts different. Keep them different so you don't get confused. The key takeaway here, and the point that many people miss, particularly if you're trying to DIY this stuff, which I do not recommend that you do. If you try to DIY this stuff, if you do title transfers and you do not do it both to the trust name and the trustee name, you have not properly converted into that trust. Never let real estate remain in your name if you've set up a trust. Now I'm going to stop for just a minute and provide you some clarity on this. Remember, there's two types of trusts. There are revocable trusts and irrevocable trusts. 95% of people use revocable trusts. Revocable trusts are wonderful for estate planning. They help you avoid probate court, will contests. They provide you total flexibility to manage your assets during your lifetime and a very strong succession plan for when you pass away to be able to act on behalf of your beneficiaries. However, they provide you no asset protection. The only type of trust that provides you any type of asset protection is an irrevocable trust, but there can be some downsides to that irrevocable trust. You can lose some of your tax benefits, particularly if you're investing in rental properties. So I just want you to understand two types of trusts, and there's two different purposes. If you're only setting up a revocable living trust, you receive no asset protection whatsoever. If you're setting up a land trust, remember its purpose. The purpose of a land trust is to help you avoid doing these title transfers from your name into an LLC, or if you're looking to try to help establish privacy in the exchange of the title, getting your name out of title, land trusts are wonderful to be used here, but they are two very different types of trusts with two different purposes. Okay, now let's cover the second important topic here. What if it's not real estate? What if it's not your personal residence? What if it's a business interest? You might be wondering, how do I set up a trust to transfer a corporation into? Or maybe I want to transfer an LLC into my trust. So let's break all this down. Right now, if you were to look at one of my LLCs, it would show that my name, I am listed as a member of that LLC. But here's the thing, I also set up a living trust to take care of my personal affairs to help me avoid probate court when I pass away. If I keep my LLC in my own name and then I pass away, my LLC will have to go through probate proceedings in order to pass on to my beneficiaries. And here's where it gets tricky. Imagine if your beneficiaries are now involved in a divorce or a lawsuit. That LLC would now be entangled in their legal issues. It might be something that a creditor or an ex-spouse might decide they want to take a stake in. So how do we prevent this from happening? How do we ensure that your LLC can transfer to your beneficiaries without getting entangled in legal complications or in probate court? The key here is to fund or transfer those interests into your living trust. And here's the best part. It can be much simpler than you might think. Let's break it down. To move your business interests, let's say your corporation or your LLC, into a living trust, you need to use what is known as an assignment. Imagine filling out a document where I could say, Jeff Hampton hereby assigns 100% of my membership interest in Redbox LLC to my living trust. I could then sign the assignment, the trustee of the living trust could sign the acceptance, and now that acknowledges the transfer of that interest into the trust. And by doing this process of using an assignment, the LLC is now held and controlled by the living trust. By doing this properly, you have effectively protected your business interest and ensured that they won't get caught up in probate court and they're protected from someone trying to come in and litigate it. This is really important to do ahead of time because by doing this, not only are you safeguarding your assets, but you're making it much easier on your loved ones. Now, here's an important thing to consider. What if you have multiple business interests? What if you have 4 or 5, or I have some clients that have as many as 80 or 90 LLCs? It is very possible that through one assignment, all of these business interests can be assigned into a living trust. This step is so crucial because it's one of the biggest mistakes that I find that people make and attorneys make when it comes to making sure assets are transferred over into the living trust. If you overlook this step, you are leaving those assets outside of your estate plan and you're making them vulnerable to attack. But wait a minute. What happens if I assign all of my LLCs into my trust? Doesn't the operating agreement on my LLCs still list my name? Yes, it does. And option number 1 to address that issue could be to restate your operating agreement. You could effectively update your operating agreement and list your living trust as the new member, effectively removing your name. This means the trust holds the membership interest and essentially does the signing as a member. This is a very simple way to make sure your asset protection goals align with your estate planning goals so that if something bad happens on either end, one doesn't hurt the other. But wait a minute, Jeff, I'm a real estate investor. I know I have people ask me this all the time. Jeff, I'm a real estate investor. If I'm not careful how I arrange all this, couldn't this affect my ability to obtain a loan later? When you show your living trust as a member on your LLC, there's a good chance that your lender is going to ask to see the trust document. And guess what? Once they have it, there's a good chance they're going to peek inside, and that could invade the privacy you were looking to set up. So what's the solution here to both maintain your privacy, but still be able to make sure you can maintain your lending flexibility? This breaks down into 2 steps. Step number 1, assign your interest over to your living trust, making it the owner. But step number 2, keep your name on the operating agreement as both the member and the manager of the LLC. This way, when you're working with banks, your personal name is on the paperwork, but you don't have to reveal the specifics of your trust documents. So notice what we've done by this approach. Your business interests are securely integrated into your estate plan, and your privacy interests are protected. Okay, we've covered LLCs, and we've talked about some of the important aspects of transferring real estate and business interests into the trust. But what about corporations? Fortunately, the process for corporations is pretty straightforward. Simply redo the stock certificates, indicating that the trust is now the owner, and update your stock ledger. There's usually no reason to update your bylaws. That means the corporation can continue with the same officers and directors as they've had before. Okay, we have one more crucial area we need to cover, and that is your investment accounts. This brings me to a question I actually received from someone on my YouTube channel recently, and they asked this. They said, when it comes to transferring investment accounts to a living trust, should I just list my living trust as the owner of the investment account, or should I set up a transfer on death provision with my investment account provider? So what do we mean by a transfer on death provision? This would be essentially you picking up the phone and calling Charles Schwab and saying, hey, Charles, or whatever representative is, hey, listen, I really want my account to automatically transfer to my beneficiaries upon my death. And this is a valid way to be able to make sure on the front end to show that your investment accounts will transfer upon death automatically. You would end up needing a death certificate and proof of that, but that is one strategy you can take. Alternatively, you could transfer the account itself into the trust. But here's an alternative that I would suggest you consider. I personally keep my investment accounts in my own name. Why is that? Because when I'm applying for a loan, banks and lenders want to see assets titled in my own name. It always makes the approval process much smoother because lenders can see these assets associated with my personal name. Plus, many clients actually express privacy concerns here. They don't want their trust names linked directly to their investment accounts, which may reveal how much money they have. By holding the account in my name, I maintain privacy and I have tangible proof of assets when I want a loan. Additionally, when I'm trading, whether it's in my name or my LLC's name, I don't want my trust name displayed as the account owner. Again, this is all about keeping things confidential. But here's the catch. If I pass away with the account solely in my name, it's going to still end up in probate court, causing all kinds of problems for my beneficiaries. So how do we sidestep this issue? Enter the transfer on death provision. By setting up a transfer on death with my account custodian, my investment account will now automatically transfer over to my trust upon my death. The account still lists my name, Jeff Hampton, but it also includes a transfer on death to the Yellow Jacket Trust. This means when I pass away, the account moves seamlessly into the trust without any need for probate. My trustee, and then eventually my successor trustee, can then distribute or manage those assets on behalf of the beneficiaries I have designated. This approach allows me to maintain control and privacy during my lifetime. It allows for the smooth transition upon my death for my beneficiaries, and it avoids all the pitfalls of probate court. It's a strategic way to protect your investment accounts, but also maintain that privacy that we all like. So if you are looking to balance privacy with estate planning, consider using a transfer of death provision where you keep your investment accounts in your name, but that transfer on death to your trust kicks in upon your demise. Here is the final thing that I have not covered that people will ask me about. They'll say, Jeff, okay, we've covered all these other things. We talk about real estate, my personal residence. We've talked about my investment accounts, my bank accounts. But what about my personal effects? How do I transfer my personal effects into my trust? Now, you could set up a separate personal property trust for every one of these effects, but it's ridiculous. I would not suggest you do that. It's a mound. It's literally a mountain of paperwork, and it's not worth the time and effort to do it. So there's a better solution. Simply include a provision in your existing living trust that you have already or that you're looking to set up that would say the following, quote, all personal effects that I own are hereby transferred to my living trust. This means everything. This means your vehicle, this means your furniture, literally all the gold bullion that you've invested in, everything that you have out there is now, those personal effects will now be transferred into your living trust. By that simple phrase, that clause added into your trust, all of those remaining personal effects are now integrated into your revocable living trust. You say, Jeff, does that provision really work though? In most states, it absolutely does. Always research your state laws because in some states, you'll need a separate assignment document that actually shows a true intent of transfer of ownership. But in many, many states, what we just talked about with that clause is simply enough to make it happen. There you have it. The 4 key areas that anybody's worried about when they're moving assets into a trust, whether we're talking about land trusts or revocable living trusts. We've covered number 1, real estate. We've talked about business interests. We've also covered investment accounts. And then finally, we talked about personal effects. By properly funding your trust, we're not just getting organized for paperwork's sake. We're actually setting a firm foundation to ensure you have top-level estate planning benefits as well as asset protection. So now you've got your revocable living trust set up. Maybe you've got your land trust set up if you're trying to get your rental properties taken care of. But how do you actually make sure that the next step as you build generational wealth, how do you make sure that your assets are protected from greedy lawyers if someone wants to bring a lawsuit against you? Check out this next video where I break down the entity structure that will work for you to help you protect your assets if greedy lawyers come knocking. See you over there.